Hello, Lyric Armstrong, your real estate agent and advocate. Today we are going to Judge Simpson's court, look at his landlord tenant docket. And let me tell you something, Judge Simpson brings the facts, and counselor is all objection. So we got facts and objections on site. Let's get facts out because this is going to be something. It's a real quick look at one of his cases that came before the docket, but I don't understand it. I really don't understand. Like, do people wake up and say, "Oh, I just want to go upset Judge Simpson"? I don't know if they come for him or what. Because this attorney, we were in the comments section. We were in the comments section. We're like, "Are you serious? Are you really gonna do this with Judge Simpson?" So you're gonna love this. It was funny. We enjoyed ourselves this morning watching court together in the gallery on Zoom. So come on in. Don't forget to like, share, and subscribe. Make sure you share this because this is what not to do in front of the judge. Okay, don't do this in front of the judge. All right, here we go. Judge Simpson. Let's see, where are we? Here we go. And let me make sure we're connected. Can you see? Can you hear? Hope you can see and hear. All right. Oh, he's over here now. That's the only thing about Zoom is when the judges bring in multitude of people at one time, you get everybody. Oh, he's here and he's here. You get everybody and is trying to figure out which one is for the case. So we're focused on, he hasn't shown up yet. Okay, so the attorney we're focused on has yet to show up. He'll probably be on a second later. I'll point him out to you. Another thing is, remember, everyone, when you are logged into court and you have your camera on, and then someone walks in your room, they don't necessarily know you're in court. They don't necessarily know you're on Zoom. They don't realize this is a public thing. So respect their privacy too by, keeping your camera off when they walk in, or at least let them know prior to. I'm going to be on Zoom. So when you come in on your undergarments, you're going to be on TV. Okay. She's not her whole undergarment, but I just felt like, I don't know if she really would want to be that exposed. All right. Here we go.
762 Properties versus Elijah Hendrickson.
Okay, wait, we've got to turn this up. Oh, it's up. See, this is okay. No, it's not. Like I said, this is why I turn it up, because we want to be able to hear. You definitely want to.
Good morning, Your Honor.
Okay, so here's the attorney Hugo Mack. He is going to show us what not to do in anyone's court, and I don't know why he's doing it in Judge Simpson's court. So I'm gonna put on objection before we even get started.
Hugo J. Mack, appearing on behalf of 762 Properties. With us is Mr. Mufid Farha, Your Honor, who is the landlord, and he's here to clear up some perhaps non-information from the last hearing as to how Mr. Hendrickson appeared in the apartment in the first place. So there are two issues we feel we need to address. One is our motion for immediate eviction based on health hazard. I provided records to the court. The court instructed us to have an exterminator go there. There was an infestation problem, and they attempted to treat it. It is an ongoing problem. And
y'all see how long it took me to put on objection? It's so many objections. It's on now. Okay, we're objecting to this whole hearing. This whole case is objectable. Objection.
We believe Mr. Farha, I'd like to put him under oath if necessary, Your Honor, to say that at best this is a month-to-month tenancy and there is no written lease.
I don't think I was disputing
that. Well, I thought the court was asking me how did Mr. Hendrickson get in the house in the apartment in the first place, and I really was not able to give.
Hold on. You're looking at this being a health hazard. I mean, I'll be honest with you, counsel. I think you filed the wrong type of case. I mean, if you want him out, you do a termination. But if you're doing a health hazard and the health hazard gets abated by the exterminator going in, I don't have a basis to remove him from the premises.
So what the judge is saying is, if you want me to make an order for removal, you have to file a particular matter. And the matter has to be based on termination, right? So you're terminating the lease. The counselor Hugo Mack, as well as the landlord, will attest to the fact that this is a month-to-month lease. So you just need a 30-day notice, and you want the judge to give you an order to terminate the lease. Very simple process. However, you have shot yourself in the foot because you have said that there is a sanitation concern, health concern. And when that happens, professional people have to come out and they have to prove it. They have to do reports. They have to do exterminations. Then, depending on what they're exterminating, they may have to come back over time to see if they have gotten everything cleaned out. It's not always done in a day. It's not necessarily done in a week. You have prolonged your process because you have filed the wrong matter. This is very important for all types of cases. This is why you seek professionals to do professional things, right? Because you want to ensure that when you are filing your case, you're filing in the right court, venue, jurisdiction. You also want to make sure that you're filing based on the right set of facts and that you are claiming the right allegations so that you are filing under the right matter. That didn't happen here. Didn't happen here. And I know landlord Farha, when he gets done with this day, he is going to be so hot.
Well, Your Honor, I understand what the court is saying. Our position is that the health hazard still is continuing And
so, I'm sorry, this is the reason why you go through strategy. When you go to, okay, so as a layman person, you'll go to the attorney, you'll have a consultation, and the attorney will take the facts, take some time, and then once you've retained them and stuff, they'll go into strategy. And in the strategy, that's like brainstorming for attorneys' elements as to which type of avenue you're going to take for restitution or to make yourself whole within the law. And this is why strategy is so important, because you have two-folded instances. They're looking at the situation as a health hazard that is being presented for their surrounding tenants, not just the tenant in question. But they also like overlook the fact that they are on a month-to-month tenancy, and all they really need to do is a request for termination. So let's get into some more details.
In the home.
They will be clear very soon.
But Your Honor, even if, assuming everything is exactly as you said, and I'm certainly not disputing you, then I don't know why we cannot have a request in order for this gentleman to move
the language is like so
out within 30 days. I mean, Mr. Farha's here ready to testify.
Why, Your Honor, won't you do it my way? Because he's the judge.
As to the circumstances, Judge.
Oh, wait. Do you see? Wait, let's see if we have a closer look. Let's see, where is he? Oh, he's not. Oh, here he is. So he's down here now. See, I tell you, when they add people, it gets all confusing. So Judge Simpson is rubbing his head because he now has a headache because this attorney doesn't understand why the judge just won't do it his way versus following the letter of the law. Oh, I don't know, because I don't want to get taken off the bench. I didn't cover these.
It would save a lot of time in the court's time and judicial economy.
Well, if I just step on people's rights and what the statute says, it would save a whole lot of time.
Right.
I mean, if it's a health hazard and it's corrected.
Like the nerve of this attorney. Let's save our time and step on the rights of the tenants. You asserted this particular set of rights to this tenant because you asserted that there was a health hazard.
You don't evict people.
Let me go back. Okay.
And it's corrected. You don't evict people.
Right. So, okay. So the judge is saying, if there's a health hazard and then you go and you send extermination out and you correct the health hazard, you don't evict your tenant because of a health hazard. That is not a term to evict them on. It has to be non-payment or the fact that you just want to terminate the lease. Maybe they're making the payments, but you don't particularly care for them as a tenant. And one of the reasons in this case is because they're bringing all of these, unwanted guests, these bugs and other things that need to be exterminated, that causing problems for other tenants, or maybe they have noise control issues or whatever. So if that is the case, then you, on a month to month, just give them notice, right? It's so simple, but they make it hard for themselves. And then they want the judge to fix it.
That's not how it works, Mr. Mack.
That's how it works.
I mean, I get where you may want to be, but that's not what this case is.
Your Honor, if you allow me, can I make a statement?
So this is the landlord here.
Your Honor, we would not be in this situation if this unit has been serviced 6 months ago when we used RNA Pest Service.
6 months. So think about this. If you speed through the strategy, if you overlook some details, or if you just happen to pick the wrong strategy, just maybe you thought that this was going to be a better strategy and you were wrong, it's cost you 6 months of time versus 30 days, 60 days at most.
He completely neglected and did not allow them to service the property. He allowed the basement to be infested with roaches because that's where he lives, and all the roaches moved over to the basement. The first floor, second floor was all complete.
I'm sorry. I take issue with that. So, what are you saying? Were the roaches living on the first floor and now they live on the basement? What are you talking about? What do you mean they moved? That's nonsensical. What he means to say is because of his, unsanitary living quarters, there are an infestation of these roaches, cockroaches, and it's because of the way he's living. But what he's failing to understand is when they assert that the health issue is the issue on his tenancy, that doesn't mean that he gets kicked out. That means, landlord, you have to fix it. That's the way the law works. You have to get the service out. If you've heard me talk to you guys about this anytime before, and you remember, I have said a million times, the advice I give my clients, which I am sharing that advice with you. This is just a suggestion. I'm not giving you advice. I'm only commentating because you are not my client unless you are, right? And the only way you can be is if we have a written agreement. But nonetheless, the advice I give my clients is that they make sure to have an extermination service each month. And that way, each month, the location's being serviced, and the landlord can prove that it's the tenant individually that's causing this problem in the beginning of the case. This particular case had an assertion, Your Honor, there is an infestation, there is a problem. And the judge says, okay, landlord, it's your responsibility to fix it. Landlord goes to fix it, but for whatever reason, the exterminator couldn't get out soon enough. They had some blockage, some delays, whatever have you. And now 6 months later is when they can finally come back to the judge and say, here, we have proof of the infestation. It can't be cured. Things that could have been done 6 months ago, if that was the right avenue to go down. But of course, we find out from Judge Simpson, the avenue was much more simpler because they are on a month to month. This landlord wants to get these details in, that it is the tenant that is causing him issues. This particular tenant is causing him issues with the other tenants, but he's failing to understand. You filed your attorney, unfortunately, filed the wrong cause of action. So consequently, the judge cannot just kick him out because the cause of action that he filed protects the tenant. It protects him because he can't be in squalor. Whether you think he's voluntarily being in squalor or not is opinion. But when you bring fact to the court that there are cockroaches and whatever other unwanted guests, you are proving to the court that there is squalor happening, and you as the landlord are responsible for the conditions of the property. So consequently, you have to get it exterminated. So shoot yourself in both feet, why don't you?
We still have this ongoing problem in the basement. We got it addressed on Monday for the court's request.
Good, finally.
And with their statement, they said the filth that this Mr.
Now, all of this characterization, I do not like. I don't like the disparaging comments. I mean, you gave him an apartment in the basement, so You know, is it his filth all by itself, or is there something else with the structure of the property? We could flip that coin, couldn't we? Could we not say that it's the basement is not sealed off properly? Could we not say that you have too many access points for these creatures? Can we not say that you don't have a monthly extermination membership as you should anyway, and so consequently maybe you are being a slumlord? Maybe we make those disparaging comments, because I don't like the set of disparaging comments you make as far as this filth and unheaded. Just say it's inhabitable and not well kept. All of these other details and your desire to be so disparaging against the tenant, I don't care for. Personally, I don't care for that.
Elijah lives in, regardless of what
But I don't care for roaches either.
they do, the methods will not work long-term and the infestation will still continue.
Here's another thing that you're going to find out. He's reading something. So someone said something somewhere, but they didn't give it to the court.
So he is putting the rest of our tenants at risk, Your Honor.
I don't understand.
And we've been more than fair with Elijah.
Where's
It's been
Jay?
a year since he paid
I
rent.
don't care. Hey, look,
And that is besides the point, Your
I
Honor. That
am
is
not
besides the
saying
point.
that anybody's not being fair. I'm not saying any of that.
Okay. You're
I've got a
absolutely
certain
Pay
right.
type of
attention.
case.
That is besides.
Oh, do you see Judge Simpson is so mad? Pay attention. It's not a matter of did you do what you were supposed to do to cure the problem that you've extended his stay. I guess I just now hear that he said something about non-payment for a year. So why wouldn't you just terminate for non-payment? I don't know. I mean, even that is like, that's the 20 days plus the 10 and 5 days. So, you're looking at 35 days or something that they have the ability to stay in the house before you get the writ of eviction. And that's if they don't choose to leave on their own, based upon the eviction notice that you give them. That's much shorter time than the 6-month game that you guys are talking about. And all of this is like self-inflicted. And Judge Simpson is like, look, dude, you and your attorney should have did the right thing and filed the right cause of action. We wouldn't be here today. Don't complain about how much time it's taking, because the time is on your own.
The point, Your
I'm
Honor.
not
Besides the
saying
point.
that anybody's not being fair. I'm not saying any of that.
Okay. You're
I've got a
absolutely
certain
right.
type of case.
That is besides the point. You're absolutely right.
Round,
But I
peg,
cannot risk my
square
other
hole.
tenants allowing them
You
to stay in
can
the
try to overtalk me, Mr. Farrar. It's not going to work.
Not gonna
I
work.
apologize.
Judge talks, you
Oh,
don't.
stop.
You close it. Even if you are a mid-sentence. Judge gets the floor. That's the respect of the court.
Where in the document provided to me does it say anything about what anybody is saying on this?
Right.
Well, Your Honor, I provided the court with the Orkin extermination attempt. I sent that to the court. I asked that your staff put that in the file.
I
Pursuant to
have it. Tell me where it says what was just represented to me.
Back up your facts.
Well, yes, Your Honor,
Where's your evidence?
you are correct in the documentation that I submitted to you. It does not say what Mr. Farhad just said. But the reason I had Mr. Farhad, okay, excuse me, Mr. Farhad, let me talk, sir.
Like I say, the landlord's reading something. I don't know what he's reading, because the judge is like, it's not in here. It's not in this report. It's not in the Orkin report. And now his attorney, Mack, is like, yeah, it's not in the Orkin report. But yet the landlord represented that something was in that report that no one else can find. I don't know. Maybe he's reading a specific page or whatever, but he needs to tell his attorney so his attorney can represent it to the judge. He is there as a witness to attest to facts. He's not there to clarify the record unless the judge asks him specifically. Otherwise, the judge is really asking the attorney. That's why the attorney's like, let me answer, but he doesn't know the answer.
Your Honor, so why I asked Mr. Farhad to be here to explain that at best this is a month to month. So
now we switch
I just
subjects.
want.
He's totally switched it. The first set of facts had to do with extermination and the factor that this particular tenant is so I'm gonna say his quarters are so unhealthy by the tenant's own actions that the extermination company has represented to the landlord that they cannot put any measures forth, whether long-term or otherwise, it's going to rectify, correct the issue, because the issue is really the tenant. That's the basis of the landlord statement. The judge says, show me where it says that in this report. And the attorney just completely switches gears. He's like, yeah, it doesn't say that. And, but, the month to month, that's not what the judge asked
I
you
wanted the
for.
court to know that's what we're dealing with here. Nobody is disputing that. Mr. Hendrickson is not saying he has a lease. So I'm saying if it's a month.
Did someone mute Judge Simpson? Have y'all lost your mind? Or did he mute himself? Because he's clearly talking and cannot be heard. And Judge Max is talking about no one's disputing that. It doesn't matter. That's not the case you
To month, and I'm just simply asking. I'm sorry, sir.
That was never disputed from the last hearing, that it was a month to month. You kept wanting me to evict him based upon that, and I'm telling you, that's not the case I have in front of me.
Okay, so, Your Honor, is the court saying we need to refile on the
court does not give advice.
On the basis
you asked me that the last time. I can't tell you to do that. You can either proceed based upon what Mr. Farhar is saying. I'll set it for trial, but I don't have anything in here that says what Mr. Farhar is indicating, and I don't.
Okay.
And it's
All
not
right.
a termination case. If you want a termination case, file a termination case.
Okay.
If you want a termination case, a 30-day, 60-day termination case, file one. Okay, I think the other lady has gone out of the room now.
I don't have a problem ruling on that.
All right, Judge. I understand the court's ruling on this matter, and apparently we'll have to file a termination case to
but
be sure
the judge hasn't even made a ruling. The judge says if you want to proceed with the matter that you have before the court with a cause of action of unhealthy living quarters that you have before the court, we can go to trial. But I want you to also be made aware and be mindful of the fact that what your landlord just represented is not in the filings. Those particular facts that he gave are not in the filings. So not sure a trial is going to work for you, but we can do that. And then he says, but if you want a termination case, you have to file a termination case. You have to tell the court what you want from the court, what you are asking of the court. The court doesn't turn around and say, oh, you should ask me this question. No, it will answer the question that you ask. If you ask the wrong question, you're going to get an answer that doesn't matter to you because you've asked the wrong question.
everything is to the court's satisfaction, Your Honor.
It's not the court's satisfaction.
If you want to twist it that way, Mr. Mack, I'm going to tell you, quite frankly, and if you want to try to call me out on it, I'm just going to lay it right out.
See, the judge is like, you're trying to make it seem like it's me. Now I'm going to let your client know how much it's not me.
If what you wanted to do was to terminate this gentleman's tenancy, you guys needed to file a 30-day. Then there would be no issue, no dispute, no anything. This issue regarding the spraying could have still existed, but Mr. Farhar would have gotten his property back right away. He would have had it back last week.
So, poor attorney Mac. I don't think he meant to do this. I really don't. He's probably a phenomenal attorney, and I know he knows more than I. It's just one of those days and one of those times, and we just happen to catch it on a live, right? But in knowing that we are learning and we love to learn, sometimes we have to learn from mistakes of our own or others. We take this opportunity to learn. And what he has done is put all of his foot in his mouth, because he gave this impression that, if this is what you now want me to do, judge, if this is what the court now wants me to do, which means judge too, it's interchangeable. If this is what you now want me to do, then we'll do that. We'll go ahead and file that action. And the judge is like, hold on, now I'm done, because he was really just kind of hinting along the way, trying to give him, some untold advice, if you will. And he is now like, okay, well, if that's what you really want me to do, as if the judge is somehow out of line. So now he's like, okay, now I'm going to tell on you because you have tried to throw me under the bus. Let's be real clear. It's you that has done the wrong. And consequently, it's bad on him because now the whole, web that's looking is looking, right? So when you, as a landlord, go to hire Attorney Mack, you're going to go, wait, I remember that time that you were before Judge Simpson and you didn't know what cause of action to put before the court. And you cost the landlord several months, right? Because the judge has now explicitly said, even though the issue of the spring, which is the extermination, that's what he's talking about. Even though the issue of the extermination is an issue, it could have remained an issue if all you really wanted to do was terminate the tenant's tenancy within the property. All you have to do is file the right cause of action, and 30, 60 days down the line, at the most, he would be out of there. And so you've cost the landlord this extra amount of time on your accord for whatever you've done. I don't know that it's been 6 months that it's actually been in the court's hands, but that was one of the timeframes that the landlord did express, that he's been working on this since the last 6 months. So, and he's been, not getting his rent for a year and da-da-da. So maybe the tenant was like, I'm not paying rent because the conditions of the place is so uninhabitable due to the infestation. And then the landlord replies, well, it's because you as a tenant are not maintaining the property up. But like I said, the way I have my landlord set up is that every month they're making those extermination, they have that membership for the extermination to come out every month, because then that's a provable thing. Then you can truly prove it on the onset that it's not the landlord that's is not a delegate failing at their particular duty of keeping the property habitable. It is you as a tenant that is not maintaining the property, in its cleanliness. That is something that you can prove easily if you have membership. But since he didn't, sounds like he had to have him come out and then reschedule or whatever. But now that the Judge Simpson has put it out there on the line, Attorney Mack, this was not your day. I'm sorry, you shake it off, you come back again for another one, but please, by all means, do not ever tell the judge it's his fault.
But you can't come in, file the health hazard, think that that's quicker, have me step on the rights of the defendant, expect that to be some expedient process by which you go through. You're a better lawyer than that. You should have known that.
Well,
This judge I'm not going to step on anybody's rights. I'm not going to step on this defendant's rights, and I'm not going to step on Mr. Farhar's rights. Do it right, and then I don't have a problem. So what do you want me to do? Set the trial, or you want to start over? Those are your only two options. I'm not going to argue with you. Two options. What do you want?
We will file other pleadings, Your Honor.
Then you want me to dismiss this one?
Yes, Your Honor.
Case dismissed. Jeez.
Thank you, Your Honor.
Wait, but who is, I guess Elijah is the gentleman here. And I guess maybe that was his spouse or his roommate of sort that let me cover up Madam again. That that comes on the screen and says, thank you, Your Honor. Because I never did understand who that voice was. Okay, so there.
Just do it right.
Okay.
Court calls the case People versus Lawrence Carroll versus Patrick Cox.
They just keep moving. Good
morning, Your Honor. Dan Troy appearing on behalf of the plaintiff, Lawrence Carroll.
Wait,
Yes, good morning, Mr. Troy.
So you get to kick out of Dan, I don't know what, I guess Dan's voice or whatever, but it helps him to kind of shake off the last case.
That helped a great deal. My blood pressure came down quite a bit. All right.
So, Your Honor, I understand you're very familiar with this case. I'll try to bring and I would say you probably know more than I do, but I would like to bring to Your Honor's attention what I understand has happened since the last hearing a couple of weeks ago. I will also know for the record, Mr. Carroll was present. If the court has any questions, also Township Council is present, as well as the Township Building Official. As I think the court knows, my client filed a forfeiture action, and the forfeiture, notice of forfeiture and the
So I went ahead and just went straight into this other one just because Dan heard from the last case that Judge Simpson was elevated, right? So Judge Simpson says his blood pressure was elevated, but we know that he was elevated And so Dan comes in very humble. He's like, I know you know more than me. And if you remember, this is what you know. And I know you know everything. He's like, Judge, I do not present as if I know anything more than you. Like, he comes in very humble to bring the judge back down so he can come and go over this case. He's learned very well from the last
Forfeiture
case.
complaint are alleging that there are non-compliance issues with township code, mainly the International Property Maintenance Code. And I think Your Honor was informed 2 weeks ago, Judge Freshour in Chelsea issued an order permitting the township to go in and clean up the yard, which apparently has a lot of masonry contracting debris. And the order also permits the township to replace the siding on a side of the house that was removed by the buyer over a year ago, or about a year ago, and is also a code issue. So I just found out yesterday from speaking with Township Council that the township did in fact go and clean up the yard, but they have not addressed the siding. And frankly, that's a very, very difficult issue for the township to do. I also learned yesterday that on top of the $14,000 assessment we got last year when this happened, we're going to get a new $13,000 assessment based on what just happened, and the siding issue had not been resolved. So, Your Honor, in some respects, this is similar to what the hearing you just had, in that what was presented to Your Honor is, hey, there's a condition on the property that has to be solved.
You see Lawrence over here, I think he's an attorney. He's laughing. He's like, yeah, okay, be careful. Don't bring that one up again.
We have a different judge saying, here's how you do it. Township, you can go in and take care of it. And the township did do that, except that the township has not replaced the siding. So the Judge Freshour's order and the property violations are still in effect as we speak today, as to the siding at a minimum. And I will add, by the way, I'm assuming the other outside issues were addressed by the township. Mr. Toth may contradict me on that, but that's my assumption. Your Honor, after going through this with my client at some length, I was told and would like to confirm that Your Honor has suggested you would be open to us filing an amended pleading. And what I would like to do, if the court would permit it, is to amend our complaint to keep the property violation issue, because there's still a siding issue, and also because this is recurring. We think it's going to just pop right up again in the next week, 2 or month, as it has over the last 4 years, and also to demand that we be paid the assessments, which are now like $27,000. This is a huge problem for Mr. Caro. He is between a rock and a hard place. He, without relief from this court, he's going to keep getting whipsawed with the township actions against Mr. Cox in perpetuity. And just Mr. Cox seems incapable of maintaining that property to code. And I think Your Honor may be aware from pictures, it's not a close case. We don't get it, but all indications are he's just unwilling or incapable of satisfying the township. And the township, I think, has given him, all the leeway they can. So what I'm seeing in the future for Mr. Caro, without relief in this court, is pretty bleak. It's going to be just one township action over another. And every year, 13, 14, 15 grand assessed, which means he's going to lose that property, because he can't continue as a seller under a land contract with his own mortgage and have to deal with that kind of expense. So I don't think there's any dispute that the land contract buyers are on the hook for the township expenses, which are again now around 27 grand. What we want to do then is make that claim, which I acknowledge is not before the court at the moment, but the land contract forfeiture rule clearly empowers the court to allow amended pleadings. I think that's probably the only way to force the issue. And if there's any hope that this land contract can be successfully, played out, it's got to start with some consequences for the Coxes for just being unwilling to satisfy the township. So
that was really cute. He's like, under this particular act, Your Honor, we get to amend our pleading, but he did it in a way of not being like, this is something I can do, this is the solution. He's just like, representing to the court that under the act, the rule where you can go ahead and look at amended pleadings, if you choose. Like, it's being very intentional, and he's stepping very softly, because he's not trying to tell the judge what to do. He just wants to make sure the judge knows that this is the rule that he is citing, that he can, in fact, amend his pleading and not have to go into a whole new action. It's basically what he's trying to say.
Your Honor, again, I think you probably know more about the case than I do. I've done my best to come up to speed and come up with a solution. But that is my proposal, that the court, acknowledge that we have leave to file an amended complaint that would allow the Coxes to respond and their rights will be protected. But we can then go forward and join the issues that
All
really
great
are
language, right?
affecting Mr. Carroll, that being the continued property violation, at a minimum, the citing, and these assessments, which are now, in the stratosphere as far as land contracts go. And while, Your Honor, I know it's over 25, this is not a money judgment issue. This is a redemption issue if the court were to.
Over 25,000. So small claims court, 25,000 under. That's why he said, I know there were over 25 because they're at 27.
Give us that judgment once we had a hearing.
But he says it's not relative to the judgment of finances. It's more.
Anybody else want to address the court on this? All right.
Yes, Your Honor, I'm sorry. Go.
Who's talking?
This is Patrick Cox, Your Honor.
Right. Where's Patrick?
We were assessed fines for the first cleanup that took place. And when we found out about being assessed that amount, it had been worked into our summer taxes. And I don't know how or why that happened. Maybe that's just how it happens, but that was something that that we just found out that that's how it was being taken care of. And we spoke with Mr. Carroll, and he wanted to work with us yet to see if there was a way to keep things going. So some numbers that he put together that we trust in, we have no issues with what the numbers are, based on what it would cost him over the long term. We pay a second payment to him every month on every 2 weeks to buy down what that cost is that was associated with the first cleanup, and that was all at his request. And so we've satisfied that, and we've made every payment. I did have this issue again, and it came up, and they came out and they did clean the property.
So this is where he would benefit from an attorney. I'm a little lost with his explanation. He said the first time that there was an assessment, they had they worked out, I think, with Mr. Carroll, not Carroll. So I think he's saying Carroll. Lawrence here. They had a payment plan that they did, and they were able to satisfy it. The attorney, Daniel, just represented that there's two assessments. The first time was $13,000, the other was $14,000, totaling $27,000. So maybe they've been assessed 3 separate times. They paid one off, and now they have 2 outstanding. Or Daniel is not informed that the first $13,000 was already paid off, and the $14,000 is the remaining balance or something. So it's a little confusing as to what Mr. Cox is asserting here as a set of facts relative to his payments. He's definitely asserting that the payments have been made, but I don't know if that's in response to Attorney Daniel's notations as to what's owed on the property cleanup.
And I wasn't aware.
And just to be mindful, as homeowners, if you have extra trash, let's just say, that becomes a bill to you for the pickup of your extra trash. If your trash doesn't fit in the bins, you have to call for a special pickup, and you get assessed, depending on how much weight or whatever, you get assessed how much you're going to owe for that additional pickup. This particular set of facts sounds like there's some siding that has been discarded. I'm assuming discarded in a generalized area or in an improper area, and there's been cleanup of the siding, and consequently in doing so, the township has incurred a cost, and $13,000 for one and $14,000 for the other. And if this is house siding, if I'm understanding the facts correctly, just be mindful that you can go to Home Depot and you can pay someone a couple $100s or so. You can negotiate for them to pick up certain materials from the house, that maybe if it's siding or wood or whatever, because if it's recyclable, they'll definitely want to pick it up and take it and go recycle it because they'll get some money from the recyclable, and then you pay the money for the haul away. And you can do that and save yourself a lot of trouble. But this is $13,000. So it sounds like something bigger than what I think it is. Hopefully the facts will give us some more understanding.
Aware of what that assessment charge was until just now when he said that it was 13,000. And I don't know if that.
Sir,
Yes, sir.
Mr. Cox, let me just stop you for a moment.
Sure.
I understand. Help us, Judge.
Let me just say this.
Help us.
When I was doing this lien docket, I've had this before me before. So this property is not this. None of this is really a surprise for me. I think two things.
Lien docket is what he just said, and so that's like a lien against the house is what this is. It's a lien from the township against the house. So if you don't pay a contractor or you don't pay the township a certain fees, they will put a lien against the house. That's what they're talking
Are happening here, which are causing a problem. Mr. Troika, I think, is correct that some of the issues that are being dealt with by my colleague, Judge Freshour, can be dealt with in this case. When Mr. Carroll came before me last time we were here, his fundamental issue was really getting this assessment again and trying to think of a way in which that assessment wouldn't be as against him because he doesn't think he should pay it because he's not really causing this problem. Whether I agree with that or not and how that would happen, that mechanism, it doesn't really matter. But what is really complicating this, in my opinion, is trying to have two judges resolve the same issue effectively in two different forums in two different forums. So in that regard, here's what I'm going to actually order. And this judge will cooperate to the extent it can. I think one of us, either Judge Freshour or myself, will need to handle both of these cases. Plain and simple. That way, we don't have a problem with what needs to be enforced or anything along those lines. I would allow the plaintiff to amend their complaint to bring all of those issues in, bring that other case, I guess, here. Because I'm not going to bind Judge Freshour to try to take one of my cases. I certainly would be willing to take the case. So I need somebody to raise that. Certainly I could call Judge Freshour and find out, but I need somebody to raise that to Judge Freshour. We would then touch base and the case would just come over to me. That seems like, from my standpoint, the better way to handle this whole thing. You may not like the rulings you get that come out of it, but at least
Keith is sleepy.
It's all in one spot and you can look at one judge and say they did it wrong. All right. Anybody have any objection to that process?
And Your Honor, I'll state I do not. Township Council is present. They're actually the party before Judge Freshour. Larry Carroll is not a party in that proceeding. I don't mean to put him on the spot, but if I guess I'd like to know if Township Council is okay with that, because
Mr. Lillick never wants to see me. That's okay.
No. Your Honor, Victor Lillick, as you know, I represent York Township. Frankly, the
back there, Victor.
Freshour, Your Honor, it's done at this time, except the requirement that Mr. Cox put the siding back up on the property. That's not an enforcement issue that the township's not going to take care of that. The township will go onto the property and clean up the property when it has to, okay, and only when it has to. And in this particular case, it's become necessary. So we've done that again. So that particular violation, at least for the moment, is resolved. However, we don't have any expectation that that's going to continue to be resolved. We fully expect that Mr. Cox, as long as he's living there, will probably begin accumulating materials again in violation of the
Okay. So now I do understand. So the siding is in fact a siding of a house. So I was right that that's the material that they're speaking of, but they're speaking of it in a way that I misunderstood. They're not hauling away the siding. What they're saying is that the house is really in being ready to be condemned. It's in like the potential to be condemned because the owner has taken the siding off and it needs to be put it onto the house. I don't know. I guess he's finding himself maybe a do-it-yourselfer to try and, fix up the house. Not sure. I'm just asserting that, trying to surmise all of the details. I did look up some of the township in Michigan as to what the siding concern would be. And it sounds like now that this attorney has spoken, I get some better understanding. It's almost like Fred Sanford yard, if you will, like debris of any kind, not necessarily trash, but it could be straight trash, or it could be overgrown weeds and overgrown foliage. And so if you're in a hillside, especially where I am in the Balma Vista, you have to have your grass and your ivy or whatever cut low during certain parts of the year, especially when it gets really hot over here in California, so that it doesn't set wildfires. That's the whole idea. You cut it low and you keep it wet. The other thing that may be the case is if you don't want to attract different rodents and different animals, you'll keep it cut real low so that they're not rummaging through the area using it as a haven, right? So it may be a city concern or a township concern in this regard to have certain weeds and certain landscaping measurements in place. And it sounds like the attorney has said if the township does not go and clean the property just voluntarily and arbitrarily, it does it when it has to. So when it has deemed that the space is out of control and needs to be cleaned up for health concerns, what I looked up is usually that's when they get involved, or for whatever the township ordinances are relative to the space, that's when they'll get involved when it's out of control. And so I understand those details a little better now. I was trying to figure out, like, what does siding have to do with anything? But I guess this particular owner just has his siding down for whatever reason, and they want him to put it up and get his house in order so that they don't have to condemn the house. And the other thing is they have these liens against the house. The owner feels like he's paid one of them, so I don't know about the other one, but that's another way that the township could gain ownership of the property is in order to get the property sold so they can get their money back. Quiet as it's kept, people feel like, and this is true for my people, I know this is true, that property has been taken from them, but a lot of times that property, whether it's taken legitimately or otherwise, is not taken so they can stay on the city or the township's ledger. It's so that they can sell it and make money off of it, right? So I doubt that they want to keep the property, right? So if they do get it, if they do have it in a sheet and they do claim ownership of the property because of the lien, then they're going to have to sell it.
The township ordinance, and frankly, the court's ordinances.
And they want the money because they need to pay their employees, their salaries and stuff. That they need money to operate. That's why you have tax lien sales. They have taxes, they have liens on the property. You don't pay it, they take the ownership of the property and they sell them because they need the money.
So, I don't have an objection to one judge handling this case. I would just indicate to the court that from the township's perspective at this point, we're pretty much done until we have to go back in and enforce the order again.
So, and Your Honor, if I may.
Right, but and that I think is where the problem can come in terms of enforcing the order and coming back again. And that's what I'm trying to prevent, because you'll be headed back into one court. Then next thing you know, this is Mr. Carroll's coming into here to do this. It just doesn't seem to me to make any sense to do it that way. So.
Fair enough, John.
And you guys are, you know, the last 3 times you guys have been here anyway, so I have
True.
2 here. So, all right. So why don't I do this? Go ahead. What were we gonna say?
I was just gonna say, as far as the, administratively, how this works, I mean, do you contact Judge Freshour or?
I will let Judge Freshour know, but it would be best if the township let Judge Freshour know, or something, the parties here let Judge Freshour know, and then we'll touch base.
All right.
I'll try to do.
I'll reach out to her administrator.
Maybe just file a notice.
All right. So I'm going to adjourn this to August 18th is my next.
Yes.
August 18th, 2023 at 9 a.m. And that way it'll allow you to get what documents you need here. I'm sure the 2 courts, once they're contacted, we can then get the file over here if necessary, and start moving this along in a more streamlined fashion.
Yes,
Okay.
and Your Honor, I'm sorry, if I might, Your Honor, there is actually a hearing that's scheduled before Judge Freshour on the 30th of August, okay? Now, if Mr. Carroll, okay, filed a motion in that case. He's not a party to the case, and so I'm not certain.
Yeah, I know.
Okay, all right, so
Yeah.
in any event, that's scheduled for the.
Yeah,
30th. I just wanted to-
Mr. Carroll, I think, had indicated he had filed the motion, was looking for me to rule. I couldn't rule on it. And I knew he was I knew he was filing a motion. I didn't know when it was scheduled, but so that's set for the 30th.
Yes, Your Honor.
And that's set before Judge Freshour.
Yes, it is.
And so if everything were to come over to me, then Judge Freshour wins, because then she doesn't have that hearing. I don't think she's going to have an objection.
And Your Honor, we can address that motion on the 18th. I mean, not hear it, but we may need to withdraw, refile it. That was prepared by my client in pro per. I don't actually know what it says, but we will have an opportunity to meet with the Honor before we have to deal with that motion. And it's possible we'll, in the meantime, have worked things out with the township.
All right, very good. Then what I'll do, I think everybody has their marching orders then, and I'll see you guys on the 18th.
And Your
9
Honor,
a.m.
we will in the meantime file an amended complaint.
Yes, sir.
So
Okay,
that's the 18th at what time, Your Honor?
that'll be set at 9 o'clock. You may 9 o'clock block.
Thank you, Judge.
Thank you.
Thank
Your Honor.
you.
Thank you.
folks.
All right, so there's that. That's interesting on a couple of levels. So Judge Simpson's court still does block hearing sets, and then we know Judge Middleton has cited that Michigan appeals, a court has required Michigan to set a particular time for the hearing, not just a block. Another thing that we got out of that particular hearing was, the second one was to consolidate, right? To bring the two together. And of course, no judge wants to step on another judge's toes. So I don't think Judge Simpson is making that effort at all. He is just asserting that let's keep it simplified. And quite actually, he's probably doing the other judge a favor so that, that is now off her docket and can get on his docket once all things transfer. For the notice, I would just do a notice to the judge, have the minute order from this particular hearing that shows that Judge Simpson is requesting or has advised that it'd be best to consolidate the matters, and then just do a notice to the judge to that effect in the other case and get that matter consolidated. But I also heard some elements. So I was trying to figure out where Larry Caro, trying to figure out where he fit into everything, and he sounds like he's a plaintiff, but he's not a party in the other matter. but he's a party before Judge Simpson's matter. And it sounds as if the, like I said, I'm getting these facts based on what they're asserting. So, it may not be precise because I don't have any of the pleadings, but it could very well be that in some instances, this has happened and it can occur, that you have a sale of a property and the seller of the property has sold the house with liens on the property, township liens and cleanup liens and trash liens and different things that are small liens that go on to the title. If you don't have a title company running a full title check on the property, can be missed. It can be little clouds on the title that you don't necessarily know about because you don't do a full title check. So make sure that you are using professionals to do professional things. Like that is just going to be the theme of it all. You have to try and get professionals. And if you need help getting those professionals, I am here for you as your realtors. I am in California, but as I state, I have several realtors all across this nation that I can refer you to. But that's important. That's very important. That's what it sounds like the element was that, one person was selling to another person and they ended up, collecting all of these liens. And now it's 27,000 or 14,000, 13,000. Like the actual number amount is not ironed out yet. And that mostly is on twofold. One, that there's a new attorney to the matter. So he's not asserting that he has all details. He's trying to figure it out. And the other is that I guess the defendant, Mr. Cox, is representing that he's made payments already. So they're going to have to iron that and see if that payment set was for one of the citations or one of the lien amounts that's on the property, or was it for something separate? Now, what I will say though, however, is if you are an owner of property and you set up a lien payment schedule and then you sell the property, the lien is attached to the property. So if you've made a payment schedule and you haven't paid it off and you have to get a reconveyance, which says we remove the lien, you now have a clean title, or at least your title is, clean from this particular cloud. If you don't get that, certifying that you've made payments and that lien is no longer valid, it just continues to go. Wherever you sell it, it will continue to go with the property and it will continue to pop up. So, the new owner will get a notice saying that this is outstanding. So you can't just sell property thinking, oh, I've made payment arrangements, I'm making payments on them. Even if you feel like you've made the last payment, you have to get cleared of that and you have to get your reconveyance. So that you can file that with your title so that you can have clear title of that lien and get it removed from your title. So there's processes that needs to take place. So once again, not advice, just commentary, suggestions, things I know and things I'm learning with you, right? We're here learning together as we watch Judge Simpson. But that first case, learn like Daniel learned, attorney Daniel learned on the spot. Learn like he learned. Do not go to court knowing more than the judge, okay? You just don't. You just don't. Even if you do know more, don't present like you know more because it's not going to go over well in many instances. And quite honestly, if you knew so much, then why aren't you the judge, right? So I don't know. But just maybe you do. Maybe you happen to know more. Keep it pinned up, Make sure that you're presenting things in a manner of humility, right? You're giving the judge the respect that they have earned, or at least that they've been awarded through the robe, and one that you would want to get in return. So even though you may dispute, because you don't necessarily have to agree, and of course the judge says you probably won't agree with me, right? You heard Judge Simpson, you're probably not going to agree with the ruling I have. I'm sure somebody's going to be mad because obviously one person wins and one other person loses, right? But overall, at least you don't have to go to two courts. So that was the way he ended the second one. But from the first one, we learned that even if we do know more than the judge, which Judge Mack just wasn't his day. He was not getting it that day. But even if we do know, we need to present it with the humility that Daniel gave. Judge, I know you know more than I. And I'm sure that the court remembers X, Y, and Z. See, that's a good way to show the court that this is the facts, this is what it is, but you're not telling the court, I know more than you. You're like, no, Your Honor, I know you know it all, but I'm just expressing that, just as to help refresh your recollection. X, Y, Z, 1, 2, 3. Here are the details. Here's this, and this particular rule would apply. And if you allow for us to amend our pleading, we can amend our pleading and go ahead and move forward with the set of facts of X, Y, Z, 1, 2, 3. He gave a very much more, much more humble presentation. And at the end, Judge Simpson was like, okay, you're right. Let's amend your pleading. And as a matter of fact, amend your pleading to include all of the facts. Let's just take this case as a whole hamburger. Let's not cut it in half to the other judge and half to me. Put the whole hamburger on the plate, and I will be the one to bite it. I don't want to, but I'll do it. I'll take it on. All right. So I hope you learned a little bit, had a little bit of fun. As always, Judge Simpson's court is a hoot. Love him. Thank you, Judge Simpson, for presenting to us a great landlord-tenant instance. We have learned from our landlords have been informed that, when you have health concerns in the location, you are now putting the tenant in a place of his rights to be exercised, and consequently, you as the landlord must abide by the laws of keeping the location habitable, especially if you want to, collect rent. You can't collect rent on a place that's inhabitable. If it's not able to be lived in, then you can't charge for someone to live there. And so be careful with what you file. Make sure you're choosing the right cause of action, and make sure the place is habitable. I mean, for goodness sakes, it's very simple. Every month, have an exterminator come out. I really do mean what I say about living in a, I want to say dungeon, living in a basement. I grew up in DC, and I know what it's like having a basement. And in one house that we had, I would never go down in the basement. I just wouldn't. It was so dark. It was wet. It was just like, no. And then the other house we had, the basement was really nice. It was, rehabbed into a great living quarters. So, it can be done. It can be a nice space. I don't know what his space was or wasn't, but I just didn't like his willingness and his seemingly desire to present inhabitability and to disparage the tenant. And it turns out that it seems like the tenant was on the line too. And I hope that tenant is not, causing the issue, but at the very least, I hope the tenant is not embarrassed by some of those statements that just didn't need to be made, because quite honestly, they had the wrong cause of action. So to prove and to disparage the tenant in any way did not serve the landlord at all, because they had the wrong cause of action. They filed the wrong pleading. When you check the box, check the right box. When you insert the cause of action, insert the right cause of action, because you waste time. Now, all is not lost. They can start over. They're probably still within the same statute of limitations. It's a month to month anyway. So, 30-day notice is really all we need to do in California. Not sure other states, but for us, if you're on a month to month, you just give them the 30-day notice, and that's all you got to do to terminate. So hopefully it will be just that simple for them. Whatever the case, they've learned a good lesson now. And so have we. So make sure you like, share, and subscribe. Everyone else needs to know too. Maybe they want to be a landlord. Don't have the fear of being a landlord. Just get informed. Maybe they are a tenant. Understand your rights and know what processes are important to take and how you are supposed to act in your responsibilities as a tenant as well. All right. Like, share, and subscribe. Lyric Armstrong, your real estate agent and advocate.